3,000 times earnings or 3,000 times sales 10 years out, because you don't judge companies based upon price-earnings ratios, you judge them based on eyeballs. How many eyeballs did they get? How many people look at this stuff? So of course you had these valuations that were just off the charts, and all that came home to roost in March of 2000. Then it went down March, April, May, June, July, August, it went back up, and then it went straight down to the summer of 2001. And in summer of 2001, everyone said, oh, things are getting better now, things are coming back. And of course 9/11 came along, the security prices went down from September 2001 to October 2002, which was the bottom. And from October 2002 to the present, we're up about 26%, as measured by the S&P. So the point I'm trying to make, and I apologize for getting there in such a roundabout way, was that all those tech wreck cases, all those people who had damages back in 2000, 2001, we're now in 2007. So a lot of their claims are becoming stale. So no matter what, if the broker did something wrong, the events giving rise to the claim occurred in 2000, 2001, when the securities were recommended, and certainly when the client was aware of the damages, which is one of the elements they have to be aware of for the claim. So that, hey, you should know about this because back in 2001 you suffered these damages, so you're on inquiry notice at least. More than 5 years have elapsed since the events giving rise, so guess what? You're out of luck. So there's been a movement by the respondents bar, probably starting in 2004, although some of our opponents would start serving them earlier, motions to dismiss. We would see, I think when you file an answer, even when I've done defense work, I'd rather file a motion to dismiss than an answer, because at least with a motion to dismiss, I'm forcing the panel to look at the law. I'm going to be able to summarize the law, put in the relevant case law, write a nice brief as to why this claim is deficient for whatever reason, and I'm going to force the panel to look at it. Whereas, if you just file a simple denial or a simple answer or a simple narrative, you're not going to really put the law in front of the panel. But in the last 3 or 4 years, it's become a really important part because panels now are starting to see stale cases. And respondents are filing motions to dismiss saying, hey, these people are not entitled to their day in court. This claim should be dismissed because it's too old. This claim should be dismissed because it's ineligible. This claim should be dismissed for a variety of legal reasons. Now, arguably, the legal reasons don't apply in folklore arbitration because, again, the legal niceties that are supposed to apply to court proceedings and to contract arbitrations, scholars will tell you they have no place in folklore arbitration. But nonetheless, I guess it was recently, as a few weeks ago, back on September, I believe it was September 19th, the NASD is subject to approval by the SEC. A new rule that says that dispositive motions are no longer allowed under the code. The only time you'll have dispositive motions is, number one, the parties previously settled the case, in other words, there was a release. And that's kind of interesting too, because a lot of times you'll see cases where a client complains, the broker-dealer says, hey, we'll give you back $5,000 or $10,000, but you got to sign this release over here. And then the client really lost $200,000 or $300,000, doesn't even know that the securities that are in their account are going to decline in the future by $200,000 or $300,000, and the broker engages in normal conduct, are going to sign this release, and later on the client's going to want to sue them, and of course the broker-dealers will say, hey, you gave up all claims, including those you weren't aware of, and as language you'll typically see in these releases are, from the beginning of the world until the date you sign the release. Okay, that's the language in every release. You're giving up your claims from the beginning of the world to the date you sign the release, including the ones you're not aware of. So if you settle a claim for $5,000 and later on it turns out with the benefit of counsel, you really have a $200,000 or $300,000 claim because maybe at the time you signed the release your losses hadn't materialized, well, under the new rule even, parties are going to be able to have that dismissed. The second one is a factual impossibility. I haven't really figured out what that means. I don't know what kind of claim would be a factual impossibility. The only possible explanation for that is, let's say they named the wrong broker. It was, Mr. Smith the second, and then you named Mr. Smith Sr. I mean, other than naming the wrong party or suing the wrong brokerage firm, I can't imagine any responsible claimant's lawyer filing a case that turned out to be factually impossible. You see, you have buying, let's call them interest groups in these cases. You have people like me, who's a member, let's say, the PIABA, the Public Investors Arbitration Bar Association. I belong to a group of other lawyers across the country, and we all do claimants cases. In order to belong to this club, you have to do so many claimants cases. You can't represent more than